Hello and welcome to this presentation, which will see us delve into what equity law is all about. So to do so, we will be covering a range of topics to get you started on this intricate subject, which will include the definition of equity, its historical development, specific statutes and case law that is applicable to equity, and that also really captures its essence as well, and also the different equitable remedies available to you when you utilize equity. So before we begin, as always, let's talk definitions. So to set the scene, let's first look at the etymological root of the word equity. So we can see that equity comes from the Latin words equius or equitas, which I'm probably not pronouncing properly, but it's okay, which developed to the Old French equité, all meaning equal. So the literal definition of the word equity means that which is equal, fair, and impartial. Now I would like to briefly touch on the differences between everyday English words versus their use in a legal or a law context. So what do I mean exactly? Well, the meaning of words in everyday English, so their common usage and how we use them on a daily basis, is actually often completely different to what they mean when we look at their legal definition. So legal English actually has been termed its own language as such, which is sometimes referred to as legalese or legal jargon or legal speak. So what this really refers to is the language that is used by people within the legal community used to communicate with each other, which the typical individual who hasn't been educated in this language use may not understand at all. Or they think they understand, but they really don't. We cannot use an ordinary dictionary because these dictionaries may not be accurate or they don't provide the true essence of what the word means in a legal context. So this means we have to use law dictionaries if we want to know the law meaning of words, which makes sense, right? We can't assume that we know the meaning of a word when it is used in a legal context. So to grasp the definition of equity, it's first important to touch on the definition of legal, because through this we can begin to see a very clear distinction between the two. So one definition states that legal is cognizable in courts of law as distinguished from courts of equity, construed or governed by the rules and principles of law, in contradiction to rules of equity. And another definition states of relating to or involving law as opposed to equity. So you will notice here how I have highlighted the words distinguished, contradiction, and opposed. Now this is because it is key that you begin to see that there is some sort of difference between the two, which obviously we'll be going into more detail, but you can see there's a clear difference between something that is legal and something that is equitable. So I hope that looking at the definition of legal, you can see this quite clearly. So now let's get into equity itself. So there are a few definitions that are quite long, but I feel that all of this information is important for you to know. So I would like to spend some time looking at these definitions in all their detail. So the first definition states that equity is the following. In its broadest and most general signification, this term denotes the spirit and the habit of fairness, justness, and right dealing, which should regulate the intercourse of men with men. The rule of doing to all others as we desire them to do to us. Or, as it is expressed by Justinian, to live honestly, to harm nobody, to render every man his due. It is therefore the synonym of natural right or justice. But in this sense, its obligation is ethical rather than jural, and its discussion belongs to the sphere of morals. It is grounded in the precepts of the conscience, not in any sanction of positive law. So the next definition reads as follows. In one of its technical meanings, equity is a body of jurisprudence, or field of jurisdiction, differing in origin, theory, and methodology from the common law. So it is important just to touch here on what jurisprudence and jurisdiction actually mean. So jurisprudence refers to the study and the theory of law, and specifically how laws are made, applied, and then interpreted. Then jurisdiction refers to the legal power or authority that a court has to be able to hear and decide cases that are brought before them. So with this in mind, let's continue with the next definition, which reads as follows. In a still more restricted sense, it is a system of jurisprudence or branch of remedial justice administered by certain tribunals distinct from the common law courts, and empowered to decree equity in the sense last above given. Here it becomes a complex of well-settled and well-understood rules, principles, and precedents. So again, notice the highlighted words, for example, differing and distinct from the common law. Again, this further demonstrates that there is a difference between the two. So some definitions from a more modern dictionary state that equity is 1. Fairness, impartiality, even-handed dealing. Then 2. The body of principles constituting what is fair and right, natural law. Then 3. The recourse to principles of justice to correct or supplement the law as applied to particular circumstances. Specifically, the judicial prevention of hardship that would otherwise ensue from the literal interpretation of a legal instrument as applied to an extreme case, or from the literal exclusion of a case that seems to fall within what the drafters of the instrument probably intended. And going on further, 4. The system of law or body of principles originating in the English Court of Chancery and superseding the common and statute law, in brackets together called law in the narrower sense, when the two conflict. And 5, a right, interest, or remedy recognizable by a court of equity. So from these definitions, we can begin to highlight the distinctions between legal and equity quite clearly by now. For example, equity focuses on fairness and impartiality. It follows the idea of do no harm to others. It is used to correct and supplement the law when it's used in particular circumstances, with the specific intention of preventing hardship, which is really key. And when also there's a conflict between the law, so referring to common law and statute law in the narrow sense, then equity will have the final say. So to really understand equity, you do need to understand the brief history of why this branch of the law was developed originally. So let's have a look at that now. So equity developed in medieval England as a response to the rigidity of the common law at the time. So at the time, and in certain circumstances, the common law courts, they couldn't provide a proper remedy that people were after. So what would happen is these people would take things up to the king for the king to deal with it. And the king, obviously getting so many requests, he began to delegate these cases that people would bring to him to the Lord Chancellor instead, who would act on his behalf. And he's also referred to as the keeper of the king's conscience. So over time, they began to develop what was known as the Court of Chancery, which was basically a court specifically used to administer equity, completely separate from the common law courts. So what would happen is that in the past, people had to figure out if their case belonged in the common law court or if it should be in the court of equity. Because if you brought a case that should be regarded in the courts of equity, but you brought it into the common law court, or vice versa, you would basically get your case thrown out. And you'd have to go to the right court, which obviously is not ideal and could be quite a costly mistake to make. The result of this is that these two sets of courts would get into conflicts with each other all the time because they just were lacking communication. So they would get into conflicts regarding literally the same cases. One court would come to one conclusion and then the other court would come to different conclusions because they're using different rules and all that stuff. So it really became a nightmare trying to figure out whose judgment to seek in the first place. So eventually, people realized maybe we should merge these two courts together. So they did. They decided to merge the two courts into a single court structure. that would administer both the common law and equity at the same time. So this was actually done through the Judicature Acts of 1873 and 1875. So nowadays, what we have is that common law and equity are administered at once. However, it is said that equity prevails, so it is considered superior, which we're going to get into more detail coming soon. So very briefly, let's touch upon the nature of equity. So equity has been said to mitigate the rigour of the common law, so that the letter of the law is not applied in so strict a way that it may cause injustice in individual cases. This is exactly what we saw from the definitions we discussed previously, right? Where we got a real sense that there was a big focus on avoiding hardship for individual cases brought before the courts. And additionally, equity appears to imbue the courts with a general discretion to disapply statutory or common law rules whenever good conscience requires it. So we can see that equity does allow judges the option to disapply statutes or common law to a particular case that's brought before them in the court, right? This is only if they are convinced that it is the right thing to do. So again, it's with the aim of avoiding hardship wherever possible, which is one of the aims of equity. And lastly, there's the idea that equity is a form of natural justice, which means it has a moral basis. So again, this relates back to the idea of do no harm to your fellow man, which we touched upon when we looked at the definitions. So through exploring the definitions, also the history and the nature of equity so far, hopefully you will begin to get a picture in your head that the at-law side of the law, which is the term I'm using when referring to statutes, common law, international law, conventions, and all that kind of stuff, how this side of the law differs from equity. So they are distinct from each other, but they very much interact with each other. And hopefully you can see that visually. The way I like to think of it is as if these two branches of the law interact and dance with each other through a permeable barrier as such, which gives the room needed for these two to interact, but to still remain distinct from each other. So I hope that this description and this visual is helpful for you as well to begin to get an idea of all of this in your head a bit more clearly. And you'll begin to see as well that these two branches of law have their own characteristics, which are useful or not so much, completely depending on the context and also the application. So we can see that the at-law side of the law is concerned with following the letter of the law. So this means the words are taken very literally. For example, if there was a law that stated you cannot stand on two legs, then you cannot stand on two legs. There will be little consideration for how that law would impact any of the parties involved. So, for example, if the law said you had to run 20 miles per hour, but you physically can't do this, the law wouldn't care that you physically can't do it, you would have to find a way to do it. So the at-law side is considered quite fixed and rigid in this simplified sense, which isn't necessarily a bad thing as such. However, in certain situations, a fixed and rigid system simply will not cut it, right? And it's more likely to cause damage than to remedy anything. So equity is focused on following the spirit of the law. So if we go back to the idea that I mentioned earlier about a law stating that you cannot stand on two legs, well, equity will recognize if you cannot stand on one leg alone, because maybe you have bad balance, for example, and you're likely to fall over, then equity will want to avoid you hurting yourself, so you would be able to stand on two legs. And that law would be disregarded when applied to your specific situation, for example. So hopefully this demonstrates that equity is very much concerned with the impact of the law on the parties involved, and equity is more flexible and adaptable in that sense. So again, the reason why we have these branches of the law is not to say that one is better than the other, but it is to say that together they balance each other out and ensure that the law resolves issues in the best and most comprehensible way possible, So this can only really be achieved when you have the two branches of the law working together in unison. So now we move on to the Senior Courts Act of 1981. So we mentioned earlier that equity supersedes the common and statute law when there is a conflict between them. So this has actually been codified into statute under the Senior Courts Act 1981, section 49, subsection 1. The exact wording of the statute reads as follows: 49. Concurrent administration of law and equity. Subject to the provisions of this or any other act, every court exercising jurisdiction in England or Wales in any civil cause or matter shall continue to administer law and equity on the basis that, wherever there is any conflict or variance between the rules of equity and the rules of common law with reference to the same matter, the rules of equity shall prevail. So this shows us clearly that equity is actually administered at all levels of courts that exercise jurisdiction in England and Wales. So there is no longer a specific court that you must go to get equity. However, if you watched the previous video where we talked about the introduction to law, you may have noticed that in the hierarchy of courts section, under the High Court specifically, there is something called the Chancery Division, which does have a huge focus on equity-related issues. However, this does not mean that equity is only found in that division of the High Court only. We can see clearly, and we have statute law support for this, that equity is available in all levels of courts. So that's a really key idea to know. So now we move on to case law support for equity superseding the common law. So this actually comes from the Earl of Oxford case of 1615. So very briefly, what was the case about? Well, the case was about a dispute over a land transaction. So at the time, there was a law that basically stated that leases over 21 years by a master, fellow, or dean of a college were voided completely. So what happened was that a Magdalene College fellow granted the land to the Queen at the time, that then granted it to Spinola. The Earl of Oxford then acquired the land from Spinola and built houses and granted leases for the houses that he built. Then later down the line, there arose a dispute whether the original conveyance was even valid under the Ecclesiastical Leases Act of 1571, and if the later transactions that happened from that were voided altogether. So what happened is that the Common Law Court and the Court of Equity did not agree in their judgment of the dispute. So the presiding judge on this case, in the Chancery Court, he ruled that equity would prevail over common law in particular cases where it would be unfair otherwise. So in this case in particular, the later transactions that occurred because everyone had faith that everything had been done correctly, the Earl of Oxford even going on to build houses on the land, all of this had been done because everyone suspected that everything had been done correctly, right? No one suspected that anything had been done illegally or incorrectly. So trying to undo all of the later transactions that were all done in good faith and all the houses that were built, all that stuff, it would be completely unfair to the Earl who had done it all on the understanding that everything was legal. So this ruling established that equity could override common law to ensure fairness. So even if this meant disregarding statutory provisions completely. So a famous quote by the presiding judge, Lord Ellesmere, from this case reads as follows: "The cause why there is a chancery is, for that men's actions are so diverse and infinite, that it is impossible to make any general law which may aptly meet with every particular act, and not fail in some circumstances. The office of the Chancellor is to correct man's consciences for frauds, breaches of trust, wrongs and oppressions of whatsoever nature, and to soften and mollify the extremity of the law. When judgment is obtained by oppression, wrong, and hard conscience, the Chancellor will frustrate and set it aside, not for any error or defect in the judgment, but for the hard conscience of the party. So this quote really demonstrates the essence of equity that we have been discussing and why it was developed in the first place to complement the common law. Now we move on to the different types of equitable remedies in contrast with the common law remedies. So we stated earlier when we were exploring the history of equity that it was formed because common law didn't provide nearly enough remedies for certain situations, which obviously would leave some people at a loss when the common law couldn't account for their particular problem or their particular situation. So from the table on the screen, you'll be able to see the different types of claims and remedies available in both common law as well as equity. In terms of claims, we can see that at common law, we have breach of contract, negligence, and fraud. Whereas in equity, you have additional claims for breach of trust, to trace property, and to claim property on the insolvency of another. In terms of remedies at common law, you can see that we have damages, common law tracing, money had, and money received. Whereas in equity, you have almost 3 times as many remedies, which includes compensation, equitable tracing, specific performance, injunction, rescission, rectification, the imposition of a constructive or resulting trust, subrogation, account, lien, charge, and specific restitution. You can hopefully see that using claims and remedies from both branches of law is really where you can get a comprehensive remedy for any specific situation you may have, as sometimes the common law just doesn't provide enough, so equity will come in and fill in those gaps. So now we move on to maxims. So maxims are very key when we're working with equity, because so much of equity is based on unwritten rules of conduct. So when we say maxim, what are we referring to? Well, this is a short statement of a general truth, principle, or rule for behaviour. So you can see that a maxim in law is a concise rule that expresses a general truth which will be accepted by the courts, right? So maxims of equity specifically will have a focus on fairness and justice, as we can expect from our learning so far about equity, right? It is also an important side note that traditionally, maxims of law were written in Latin, and this is because the law and the language of the law has roots back to when Roman law was the dominating law in England, which continues to have its impact to this day in many forms, and maxims are one of them. That being said, let's explore some maxims of equity, but the English version. So first, we have equity will not suffer a wrong to be without a remedy. So this means that if someone has been wronged in some way, then equity will ensure that there is a solution to this, even if the common law or statute law cannot provide a specific remedy. An example of this would be if a contract is breached and the common law doesn't provide a suitable remedy, equity may come in and compel specific performance to enforce that contract. So in other words, it will make people act the way they agreed to act within the contract. Next, we have equity delights to do justice and not by halves. So this refers to the idea that equity provides a complete and fair solution to any problem, or tries to anyway, and will avoid partial or incomplete solutions. So an example of this is where a court may grant an injunction to stop someone doing a wrong, but it may also order for compensation as well to fully remedy the harm that has already been done. So next we have, he who seeks equity must do equity. So this is referring to whoever is asking for fair treatment must also have acted fairly themselves, which is pretty logical. So if, for example, someone asks a court for a contract to be enforced, then they must not have acted unfairly or dishonestly in the negotiation stages or the performance stages of that contract themselves. Next, we have he who comes to equity must come with clean hands. So again, this links to the previous one. It refers to the idea that whoever is seeking an equitable remedy must not be guilty of a wrongdoing themselves in the same matter that they are seeking to resolve, which again is very reasonable and quite fair. So an example of this is if there's a business owner seeking to get an injunction against a competitor for the use of a trademark, for example, well, they can't be acting illegally themselves by, for example, copying their competitor's products. It makes no sense. Moving on, we have equity looks to the intent rather than the form. So this maxim illustrates that equity focuses on the intentions behind people's actions, not just the formalities or the technicalities or the word use, that kind of thing. So an example of this would be in a situation where there's a contract that may actually be incomplete or hasn't been properly signed, but if the courts can see that there was a clear intention to be party to the contract and have it enforceable, equity may be used to enforce the contract regardless, even though at common law, because it isn't signed or completed properly, it wouldn't be considered enforceable. Next, we have equity looks on as done what ought to have been done. So this refers to the idea that equity will treat something as complete if it should have been completed. So even if the formal completion has not been done yet. So an example to demonstrate this is if someone has promised to transfer ownership of property to someone else, but has failed to do so, then equity may actually treat the transfer as if it was completed. And this is especially significant if someone has then acted in good faith and someone has then relied upon that promise to take further action down the line. So next we have equity act in personam. So this refers to the focus on enforcing obligations on individuals rather than property or things. So this touches on the three elements of jurisdiction that a court must have so that they're able to hear a case before them. So the three elements are either personam, so authority over the person. Then you have rem, which is authority over property. And then you have subject matter, which is authority to hear the case type itself. So an example of this would be when someone breaches a contract, equity can come along and order the performance of the contract, which would come about due to the personam jurisdiction, right? So to order someone to do that, to actually fulfill, to do what they promised within the contract, rather than focusing solely on the property that is subject to the contract, which the property itself would come under rem jurisdiction. So next we have equity abhors a vacuum. So what this means is that equity does not allow there to be property rights which are not owned by an identifiable owner. So in other words, if there is property to be owned, there has to be an owner. So an example of this could be if there is some trust property which has been left without a clear beneficiary, then equity will try to designate someone who can claim these property rights, which is done to avoid a situation where there's no one holding on to those rights, because the property itself or the rights to the property needs to have an owner at all times. So the law recognizes that should there be a situation where no one has a good claim to property, this is where the doctrine called bona vacantia will kick in. So this is where the crown or the state will claim ownerless property, almost like a salvage situation, to avoid the vacuum in ownership. So it is important to note that this doctrine will stand as true unless someone else can claim better title to the property and can obviously support their claim, in which case the property or the title to the property will vest back, or in civil terms, go back to the person with the better title. Next, we have equity will not assist a volunteer. So this means that equity will not help someone who has not given consideration or some sort of acceptable value. An example of this is if someone has promised to gift something to someone without ever actually exchanging the gift to them, then equity will not enforce that gift exchange if the gift giver later changes their mind and decides not to give the gift after all. So this idea is born out of the notion that if you haven't given anything up or risked getting harmed, then you don't really have any standing to make claims, which makes sense. If you haven't been harmed in any way, then you can't start making claims against other people. That just doesn't make any sense. However, there is an exception to this maxim, which is a beneficiary to a trust. So a beneficiary has not given consideration to be a beneficiary, however, equity will specifically protect them. And this is something that we will be going into much more detail in upcoming videos, so stay tuned for those. So following on from that is, equity will not permit a person who is trustee of property to take benefit from that property as though a beneficiary. So what does this mean? Well, it means that a trustee cannot use trust property that they have agreed to manage on behalf and for the benefit of someone else in a way that they are actually acting for their own personal gain. So an example of this is if someone has been entrusted with managing property for someone else, then equity will ensure that they cannot benefit from that property as if they were one of the beneficiaries themselves, unless, of course, they are a beneficiary, which is also possible. This is because trustees have to act in the best interests of beneficiaries only, not their own. And lastly, we have a trust operates on the conscience of the legal owner of property. So this means that equity will treat the trustee of property as having a moral duty, not just a legal one, but also moral duty, to act in the best interests of the beneficiaries. So as you can imagine, being a trustee is a huge task with many responsibilities involved in that role. So someone who accepts such a role, they really have to have a good and trustworthy heart and have a good moral compass, right? Because they do everything for the best interests of someone else outside of themselves, which is a huge ask, especially when often we naturally do things because we stand to benefit from it ourselves in some way. So an example of this is if a trustee sells property that was actually meant for someone else, which would mean that the money from that sale also belongs to that someone else. But say, for example, the trustee decides to keep the money, then equity will make them give the money to its rightful owner because the trustee broke their duty to act for the best interest of the beneficiary by trying to keep it themselves. So as we draw towards the end of this presentation on equity law, I would like to briefly touch upon a device of equity that is very famous and has many varied applications depending on what you're trying to do with it. So you may be wondering, what device am I talking about? Well, I'm talking about trusts. So equity is most noticeably applied in the context of trusts, which will actually be the focus of many upcoming presentations to get you well aware and familiarized with the key areas of trust law. So very briefly, what is a trust? Well, a trust is a legal arrangement where one party, called the trustee, is holding on to property, whether that's physically or just holding title to it, for the benefit of another party called the beneficiary. So this type of arrangement is enforced exclusively in equity. There's no other law form that it could come under. There are some trusts that are created through statutory provisions and things like that, but ultimately they will always be enforced in equity, especially as we discussed previously that equity prevails over statute and common law. So briefly put, equity's role is to prevent abuse and to ensure fairness, which is especially important in trust situations. The parties to a trust have different names that are used to refer to them. So the settlor refers to the party who creates a trust. Then you have the trustee, which refers to the one who is holding and managing the property. And lastly, you have the beneficiary, who is the one who receives all the benefits from this legal arrangement. So yes, trusts are hugely important and have widespread impact. So this is why our following presentations are going to focus heavily on trust and equity, to really get you to begin to see how this structure looks in reality, and maybe to even help you identify if you're a party to trust without even realizing this. So this brings us to the end of this presentation, where we looked at really just an introduction to equity law pretty much. But in doing so, we have covered heaps of topics, which have included etymological and legal definitions of equity, the history and nature of equity, the differences between at law and equity, the statute and case law support for equity prevailing over common or statute law, and also being available in all of the courts, the different remedies available at both common law and equity, the definition of maxims and the key maxims of equity that are highly applicable, and we also briefly introduced equity in action through the mechanism of a trust. So with this presentation today, I hope you've been able to get a really good idea of what equity law actually is, and you've started to see the vast possibilities and remedies available when you utilize this side of the law in your dealings with the law. So I hope you feel inspired to continue on the journey to learn even more about what equity is, especially when it's applied to real life contexts such as trust arrangements, which we will be covering in lots of detail over the next coming presentations. So as always, if you found this presentation valuable, please leave a like, share it with someone who may take advantage of this information as well, and make sure to subscribe for more law educational videos that you will definitely benefit from. So thank you for watching, and I hope to see you again in our next presentation. Bye!